Defendant Felix Verdejo Sanchez, through the undersigned attorneys, and respectfully requests that this honorable court vacates his judgment and grants him a new trial, for the reasons set forth below. Felix Verdejo Sanchez was charged in a 4-count superseding indictment filed on May 5, 2021. The 25-day jury trial against Verdejo Sanchez concluded on July 28, 2023. After 3 days of deliberations, the jury returned a partial verdict and found Mr. Verdejo Sanchez guilty as to counts 2 and 4 of the indictment, but could not reach a unanimous agreement as to counts 1 and 3. Verdejo Sanchez was sentenced for his counts of conviction on November 3, 2023. At trial, the government presented witness testimony of Eliz Marie Santiago Sierra, Ricardo Cádiz Martínez, and Luis Antonio Cádiz Martínez. Although these 3 witnesses provided testimony about various matters, they all testified as to one particular topic. Events that transpired between April 30, 2021 and May 1, 2021 with, and/or in relation to, attorney Edwin Prado Galarza. After the trial concluded, the defense found new evidence that goes directly to the culpability or innocence of Verdejo Sanchez. Specifically, we found statements made by Prado Galarza in 3 interviews with the media addressing the above-mentioned witnesses' trial testimony about him and their interactions with him. Prado Galarza's statements contradict the testimony of Luis Cádiz and Ricardo Cádiz and constitute exculpatory evidence favorable to Verdejo Sanchez. These statements are newly discovered evidence that warrants a new trial for Mr. Verdejo Sanchez pursuant to the holding in Brady 8 and under Rule 933. Therefore, we respectfully request that this honorable court orders a new trial for Mr. Verdejo Sanchez based on newly discovered evidence, for the reasons and arguments stated below. At trial, the government presented testimony by Santiago Sierra, Ricardo Cádiz, and Luis Cádiz. Of particular importance, Ricardo Cádiz and Luis Cádiz testified that on April 30, 2021, they spoke with Prado Galarza to retain his services as counsel related to the facts of the instant case. They also testified that on May 1, 2021, they went to Prado Galarza's office for Luis Cádiz to meet with him. Although the brothers' testimonies were not entirely consistent with regards to their communications with Prado Galarza on April 30th, one crucial matter is certain. Santiago Sierra, Ricardo Cádiz, and Luis Cádiz were simultaneously in Prado Galarza's office on May 1, 2021. Specifically, Ricardo Cádiz testified that on Friday, April 30, 2021, his brother confessed his participation in KRO's disappearance and death, and consequently, his children's aunt told him that she had a lawyer that could help them. The lawyer was Prado Galarza. Ricardo Cádiz testified that he then called Prado Galarza from his cell phone because he wanted him to be his brother's attorney. He stated that he told Prado Galarza that he could pay for his services in any way, including with drugs, and he offered Prado Galarza to pay him with cocaine. Ricardo Cádiz testified that on Saturday, May 1, 2021, he and Luis Cádiz went to Prado Galarza's office at around 7 or 8 p.m., where his brother met with Prado Galarza and the FBI, and there he saw Santiago Sierra with her father, Miguel Santiago Laiz, who he saw pay Prado Galarza in cash. Whereas Santiago Sierra testified that on May 1st, she went to Prado Galarza's office with her father, and there she saw Ricardo Cádiz. In sum, Ricardo Cádiz testified that he was negotiating attorney's fees with Prado Galarza, that he offered to pay Prado Galarza with money or cocaine, but that Prado Galarza was never paid. He also testified that due to the lack of payment, he assumed that Prado Galarza was upset with him. On the other hand, Luis Cádiz testified that on April 30, 2021, he spoke in his room with the aunt of his nephew's mother, Ricardo Cádiz, and his girlfriend about what he had done to KRO. The aunt of his nephew's mother, who was a police officer, then told him she wanted to help him find him an attorney. Luis Cádiz testified that on that same date, April 30th, he spoke with Prado Galarza through the aunt of his nephew's mother, that they spoke on the phone, and Prado Galarza told him to call him on a private application. In their conversation, Prado Galarza told Luis Cádiz to ask Verdejo Sanchez for $25,000. As such, Luis Cádiz allegedly sent a message to Verdejo Sanchez asking him for the money, but he did not respond. Luis Cádiz then told Prado Galarza that Verdejo Sanchez did not respond to his request, to which Prado Galarza told him that they would talk the next day, and that his lack of response meant that Verdejo Sanchez would snitch on him. According to Luis Cádiz's trial testimony, on May 1st, 2021, at around 8 or 9 p.m., he went to Prado Galarza's office. Present there were Ricardo Cádiz, his nephew's mother, and the aunt of his nephew's mother, who had put him in contact with Prado Galarza. Luis Cádiz met only with Prado Galarza in his office. They talked about the case, and Luis Cádiz made the decision to cooperate. As such, later that night, Luis Cádiz went with Prado Galarza to the U.S. Attorney's Office and met with prosecutors and federal agents when he and Prado Galarza, as his attorney, signed a proffer letter from the government at around 10 p.m. In this first meeting, Luis Cádiz gave an alleged confession to the government and provided incriminatory statements against Verdejo Sanchez. He was again interviewed by the government and FBI agents on May 3rd and gave additional details about KRO's disappearance. Luis Cádiz then testified before a grand jury on May 6th for the first time. He was accompanied by Prado Galarza. Nevertheless, Luis Cádiz admitted during trial that he had intentionally lied to the government on that May 1st meeting. Most importantly, Luis Cádiz testified that in that meeting he lied to the government and the FBI because Prado Galarza, who was his attorney, told him what to say and told him to lie, to hide some things, so that all the guilt would be on Verdejo Sanchez. For example, Luis Cádiz testified that he told Prado Galarza that he fired the gun, but that Prado Galarza told him not to say that, but instead to say that it had been Verdejo Sanchez. He also testified that Prado Galarza told him to lie about the location of KRO's vehicle and his specific actions and participation in the charged kidnapping. Not only did Luis Cádiz lie to the prosecutors on May 1st, but he also lied on the grand jury on May 6th, 2021. Once again, Luis Cádiz testified that he lied on the grand jury because Prado Galarza told him to do so, because Prado Galarza asked him to lie. Another important detail from Luis Cádiz's trial testimony is that he stated that on May 1st, he called 911 and anonymously reported the location of KRO's body near the Teodoro Moscoso Bridge so that it could be found, and not that he told Prado Galarza the body's location so that he would relay the information to the FBI. Due to the trial testimony by Santiago Sierra, Ricardo Cádiz, and Luis Cádiz related to their communications and meetings with Prado Galarza between April 30th and May 1st, Verdejo Sanchez's defense decided to seek Prado Galarza's testimony as a defense witness. Consequently, Mr. Verdejo Sanchez's defense prepared a subpoena to testify at a trial in a criminal case directed to Prado Galarza. He filed a motion requesting an order to the U.S. Marshals for service of the subpoena, which was granted by the court. As such, on July 6, 2023, the USMS served the subpoena upon Prado Galarza. Moreover, on July 8, 2023, Prado Galarza filed a motion to quash subpoena and motion for protective order, DE 650, and a supplemental motion, DE 652, jointly referred to as motions to quash, to which the court ordered Verdejo Sanchez and the government to respond. Verdejo Sanchez filed a response in opposition to Prado Galarza's motions to quash, DE 663-36, and the government filed a motion in compliance, DE 667. Prado Galarza also filed a reply to his motions to quash, DE 681 and 683, whereas Verdejo Sanchez opposed the government's motion in compliance, DE 694, to which the government filed a reply, DE 701. In his motions to quash, Prado Galarza requested that he not be required to testify as a witness for Verdejo Sanchez, arguing two initial main reasons. The subpoena was improperly served, and attorney-client privilege with Santiago Sierra and Santiago Laiz precluded him from testifying, although Prado Galarza then requested that a protective order be issued to address communications not waived by Luis Cádiz. In further requesting Prado Galarza's testimony, Verdejo Sanchez argued that the USMS properly served the subpoena and that his claim of attorney-client privilege was untimely and premature, as the defense had not informed the nature and topics of his examination. The government argued against Prado Galarza's testimony for the defense, claiming that his testimony constituted collateral impeachment and was thus inadmissible. Mr. Verdejo Sanchez further argued that Prado Galarza's testimony was not collateral, but was intrinsic, as the defense's questions were to be directed mainly towards Luis Cádiz's utterances regarding his instructions to lie to the government and the grand jury. Ultimately, the court denied Verdejo Sanchez's motion, requesting an order requiring Prado Galarza to comply with the subpoena, holding that it was persuaded with the government's motions, and as such, Prado Galarza was not required to testify as a witness for Mr. Verdejo Sanchez. After Verdejo Sanchez's trial concluded, Prado Galarza participated in at least 3 interviews with the press and media in which he provided statements that constitute new evidence in Verdejo Sanchez's case. The statements were made in 2 recorded interviews, which depict Prado Galarza himself, and in 1 newspaper article. The 2 recordings and the article depicting Prado Galarza's statements were made and published in the Spanish language. Therefore, we are including as attachments to this motion certified English transcripts and translations. On August 1, 2023, the Puerto Rican television program Lo Sé Todo published in the platform YouTube a segment titled "Attorney Edwin Prado Breaks the Silence After the Controversy That Arose in the Case of Felix Verdejo." This segment contained an interview to Prado Galarza, conducted by journalist Eliezer Ramos Navarro. On October 23, 2023, an article authored by Fernando Vélez Rivera titled, "It's a Very Aggressive Cancer. Edwin Prado Wages 2 Wars After Receiving Terrible Diagnosis," was published in the newspaper Metro. This article contains statements made by Prado Galarza in an interview to Vélez Rivera. Furthermore, on February 13, 2024, a 3rd interview to Prado Galarza was published in the YouTube channel Molusco TV by media and radio personality Jorge Pabon Ocasio, who conducted the interview. Most importantly, in the 3 interviews, Prado Galarza made statements regarding his role and involvement in Verdejo Sanchez's case. Notably, the Lo Sé Todo and Molusco TV interviews constitute the 2 video recordings depicting Prado Galarza himself making the statements. While the newspaper article depicts statements made by Prado Galarza to Vélez Rivera, who attested that the contents of the article reflect his interview to Prado Galarza, Prado Galarza's statements constitute new evidence of the kind that warrants a new trial for Verdejo Sanchez. First, the statements made by Prado Galarza constitute new evidence as they were made after the trial concluded, and thus were unavailable at the time of trial. Second, it results then that failure to learn about these statements was not due to Verdejo Sanchez's lack of diligence. Third, this evidence is not merely impeachment or cumulative evidence. It goes directly to Verdejo Sanchez's alleged culpability and his defense. Fourth, The evidence will probably result in an acquittal upon retrial, precisely because this court ruled that Prado Galarza did not need to testify on Verdejo Sanchez's behalf. Although he subpoenaed Prado Galarza to do so, his statements in these interviews constitute new evidence as they were made unavailable to defendant. There is no question that the first two requirements under right for a new trial are met in this case. We thus emphasize the third and fourth requirements. In the Lo Se Todo interview, Prado Galarza directly addressed the statements that Ricardo Cádiz offered to pay him with drugs by stating that if Ricardo Cádiz said that, he's lying. He also stated that it is absurd to bring a person they just met to cooperate with authorities to then tell them to break the law, obstructing the very thing we're working to clarify, suggesting that it is untrue that he had asked Luis Cádiz to lie to the government, the FBI, and the grand jury, like Luis Cádiz testified numerous times during Verdejo Sanchez's trial. Whereas Prado Galarza's statements in the Molusco TV interview are even more relevant to our arguments. Prado Galarza stated that the day KRO disappeared and was killed, he received a call from people, including Ricardo Cádiz, linked to Luis Cádiz, and asked him for a consult. He gave them an appointment and had a virtual meeting in which he learned that Luis Cádiz was allegedly Verdejo Sanchez's accomplice. Then, Prado Galarza asked them very specific questions: if KRO was alive or dead, and whether she was underwater or on land, to which they answered that she was dead and that she was underwater. According to Prado Galarza, he knew that KRO was not alive and was underwater 24 to 36 hours, 2 days before her body was found on Saturday, May 1st. This specific statement is particularly interesting and relevant because 24 to 36 hours, 2 days, prior to the early afternoon on May 1st means around the morning of, or even before, Friday, April 30th, which is before Prado Galarza even spoke with Luis Cádiz for the first time. According to Prado Galarza, in the morning of Saturday, May 1st, he called the federal authorities and spoke with Jonathan Gottfried to inquire on whether the federal government had any interest in assuming jurisdiction over the investigation in this case, and if so, that he could produce Luis Cádiz for his cooperation. The prosecutor requested that Prado Galarza tell him where the body is, to which Prado Galarza told him to search the Teodoro Moscoso Bridge. There are supposed to be recordings because what they told me, they had gone. They had returned. There must be a recording. About an hour later, according to Prado Galarza, the government called him and informed that they had found the body and asked to meet with him and Luis Cádiz. On that same day, May 1st, Prado Galarza met with Luis Cádiz in his office for less than 2 hours before heading together to the U.S. Attorney's Office. In their meeting, Prado Galarza gave Luis Cádiz, who already decided was going to be a cooperator, specific instructions to tell the truth, to tell the whole truth. Present in the meeting in the U.S. Attorney's Office were numerous FBI agents and AUSA Gottfried with Luis Cádiz and Prado Galarza. However, after Luis Cádiz told his story to the government, Prado Galarza realized that he was missing something essential, that he had left out a part of his version of events, and thus Prado Galarza spoke with Luis Cádiz out of the presence of the agents and instructed him to tell them the story that he had told him in his office prior to this meeting. Luis Cádiz returned to the meeting and told the entire story, including the part he had left out initially. Therefore, according to Prado Galarza, Luis Cádiz omitted details of the events, but he instructed him to tell the government the entire story, and Luis Cádiz did, thus explaining that at no moment did Prado Galarza instruct Luis Cádiz to lie to the FBI and the prosecutor on the May 1st meeting, contrary to what was testified during Verdejo Sanchez's trial. After the May 1st meeting with the government, Prado Galarza did not speak to Luis Cádiz again until the day he went to the grand jury, which was on May 6th, 2021. Before Luis Cádiz began testifying, Prado Galarza told him to be consistent with what you said before. That's all you have to say. Thus, according to Prado Galarza, he did not instruct nor ask Luis Cádiz to lie in the grand jury, contrary to what was testified during Verdejo Sanchez's trial. Prado Galarza did not have any other contact with Luis Cádiz after the grand jury proceedings and was not involved in the case, as he did not assume Luis Cádiz's legal representation. According to Prado Galarza, he learned that Luis Cádiz had said that he instructed him to lie to authorities when he testified in Verdejo Sanchez's trial. Prado Galarza had no further contact with Luis Cádiz until he found out about all the nonsense he said there. At which point, Prado Galarza found the testimony about him funny, and all he did was laugh when he read what Luis Cádiz and Ricardo Cádiz had testified about him in Verdejo Sanchez's trial. Because they made things up, those people are just making up this movie with their testimony. Prado Galarza noted that Luis Cádiz lied to the government and made a fool of himself. He suggested that Luis Cádiz testified that he changed his version of events because Prado Galarza told him to do so as a mere tactic to avoid having his plea agreement withdrawn and to justify his lies to the court at his eventual sentencing hearing. That they lied about Prado Galarza to justify themselves because somehow they're going to go the day of sentencing to say why they changed their story. Prado Galarza further stated, "Let's put this in perspective. A guy that I just met, to a certain extent, I'm giving a service to the federal government to help them solve a crime. I mean, am I going to take this person that I just met and throw away 30 years of my career for him? For the murder of a pregnant woman, for God's sake." That's what the most perverse mind that could exist would believe, because you have to be stupid to come to the federal government, help it in a proceeding, and then obstruct justice. Why? No, man, no. What need, you tell me? What need did I have to get myself in this hot mess? Or to help a person, to defend the indefensible, which is to kill a pregnant woman? Prado Galarza also stated that he knows his story, the truth, and the judge was the one who did not let him testify. Most importantly, Prado Galarza stated that if he was obligated to appear at Verdejo Sanchez's trial and testify, what he was going to do is disprove the guy. Clearly referring to Luis Cádiz, as he consistently held that he did not instruct Luis Cádiz to lie to the federal government, contrary to what was testified at trial. Similarly, in his interview with Velez Rivera, Prado Galarza stated that it would be preposterous of him having helped in the clarification of such a vile crime and leading himself to obstruct justice. It is ludicrous that everything that was said was nonsense, that they were talking crap about him and told many lies, referring to the trial testimony. Prado Galarza further stated that it is preposterous that people gave credibility to two cooperating ex-convicts who he knew for just a few hours and who had just killed a pregnant woman over his professional track record of more than 32 years. Importantly, Prado Galarza stated that to do what the guy accused me of is to throw away my 31 years as a professor at the University of Puerto Rico, my 32 years as a litigator in Puerto Rico, New York, and Florida, for a guy I just met. That is preposterous, for God's sake. In sum, Prado Galarza's statements constitute new evidence that warrants a new trial under both standards, under Brady and under Rule 33. Prado Galarza's statements are not merely impeachment evidence, although they certainly fall under the definition of impeachment evidence. The statements go directly towards Verdejo Sanchez's alleged culpability. The statements made by Prado Galarza constitute exculpatory testimony favorable to Verdejo Sanchez, particularly because they also address Luis Cádiz's allegations against him, and without Luis Cádiz's testimony, Verdejo Sanchez's conviction simply cannot stand. Luis Cádiz was the only witness who directly implicated Mr. Verdejo Sanchez in the offense conduct, and there was no other evidence that directly implicated Verdejo Sanchez. Thus, it cannot be concluded that his testimony was insignificant to the case in general and much less to Verdejo Sanchez and the jury's findings. Prado Galarza's new statements not only belie and contradict Luis Cadiz's testimony, but they provide an entirely different spectrum of possibilities and information that is favorable to Verdejo Sanchez and that he could have investigated or used at trial had they been available before. If the jury would have been able to evaluate and consider Prado Galarza's statements to that effect, the result would have certainly been different for Verdejo Sanchez. If the jury assessed Prado Galarza's credibility and found that he was more credible than Luis Cadiz, then there would have been absolutely no evidence implicating Verdejo Sanchez with the offense charged. If the jury would have heard Prado Galarza's statements and it deemed his statements credible, his testimony would greatly undermine the charges against Verdejo Sanchez. The government premised its case against Verdejo Sanchez on the notion that Luis Cadiz participated in the charged offenses along with Verdejo Sanchez and that his recount of events was accurate and truthful. Thus, if the jury were to believe Prado Galarza's statements that Luis Cadiz lied in his testimony, the government's theory begins to unravel. Given the government's emphasis on the importance of Luis Cadiz's testimony, Prado Galarza's testimony would go to the heart of each showing presented by Luis Cadiz. The government's case against Verdejo Sanchez was, at the most, sufficient but underwhelming. It relied largely in circumstantial evidence and mostly on Luis Cadiz's testimony. Notably, a determination that certain evidence is sufficient to support a verdict does not eliminate the possibility that, if new evidence is later presented, a court may grant a motion for a new trial. Hernandez Rodriguez, and this is precisely the case at hand. Prado Galarza's statements are credible testimony that constitute new evidence that could lead to a different outcome for Verdejo Sanchez. Holding that, where the government's case against a defendant is sufficient but underwhelming, new credible testimony could lead to a different outcome. Prado Galarza's testimony and credibility are of great import in the disposition of this case because a reasonable jury would not convict Verdejo Sanchez if it were to find Prado Galarza's testimony credible. Furthermore, according to Prado Galarza, it was him who clarified the crime for the federal government when on Saturday, May 1st, he called AUSA Gottfried and told him where to find KRO's body. The body was then found thanks to the information Prado Galarza gave the prosecutor, which was relayed from what Luis Cadiz told him. Clearly then, the government knew that Luis Cadiz's statement that he called 911 and was the person who reported the location of KRO's body was a lie. Yet, the government allowed Luis Cadiz to testify at trial, knowing that he would perjure himself without disclosing to the defense that said claim was false. The government knew that Prado Galarza was the person who informed the location of KRO's body and not Luis Cadiz. But trial testimony, which was what was evaluated by the jury, showed that it was Luis Cadiz who did so by placing an anonymous 911 call to that effect. Notably, the government had a duty to disclose this information to Verdejo Sanchez's defense, yet it did not. This evidence was not collateral or irrelevant. We are facing exculpatory material and information that could have been used for impeachment. But the government failed to comply with its disclosure obligations, especially considering that the obligation even extends to information known to other members of the prosecution team, such as federal and state police officers. And, in this case, the information was known to the prosecutors themselves and federal agents alike. The government's non-disclosure of this evidence certainly constituted a Brady violation warranting new trial. The government precluded Verdejo Sanchez's defense from having an opportunity to make effective use of the evidence in preparing his case and at trial, including an opportunity to investigate the information. The four requirements for a new trial motion under Rule 33 and under Brady are met in this case. Precisely because Prado Galarza's newly discovered statements are crucial direct and impeachment evidence, they constitute new evidence warranting a new trial under Rule 33 and under Brady. If the statements newly made by Prado Galarza would have been presented to the jury in Verdejo Sanchez's trial, there is an actual and a reasonable probability that an acquittal would have resulted if the evidence had been available. At the very least, this evidence provides for a probability sufficient to undermine confidence in the outcome. Therefore, this honorable court should vacate Verdejo Sanchez's judgment and order a new trial based on newly discovered evidence under Rule 33 and under Brady. The statements made by Prado Galarza are testimony constituting new evidence. This newly discovered evidence did not exist and/or was not available to the defense prior to the conclusion of Verdejo Sanchez's jury trial. Furthermore, the newly discovered evidence was also unavailable due to the prosecution's failure to disclose information. The newly discovered evidence is central to Verdejo Sanchez's with its obligations as it goes directly to the issue of guilt or innocence. This new evidence is not merely impeachment or cumulative evidence. Most importantly, there is an actual and a reasonable probability that an acquittal would result upon retrial given the new evidence. Thus, the newly discovered evidence warrants a new trial under Brady and under Rule 33. For the reasons stated above, we respectfully request that this honorable court vacates the judgment against Verdejo Sanchez and orders a new trial. Wherefore, it is respectfully requested that this honorable court grants this motion, vacates the judgment, and orders a new trial for Felix Verdejo Sanchez. I hereby certify that on this date, this motion was filed using the CMECF system, which will send notification of such filing to all September 13th, 2024. Respectfully submitted.